All right, the Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number 1 CAV 21-0391, Mendoza v. State. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side, as you know, will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and discussed this case in conference. Counsel, you may proceed.
May it please the court, my name is David Abney. I'm here today with Joel Robbins, representing appellant Mary Ann Mendoza. Over the last couple of weeks, I've been thinking about how important democracy is and the rule of law. And we've seen what happens when it's attacked and subject to destruction. But at least in Arizona and in the United States, we still have democracy, we still have the rule of law, and we still have the right to seek redress of grievances from the government, which is really what this is about, trying to get damages from the government for wrongs that government employees have committed. I'm in the unusual position of the second time over the last 2 weeks of arguing waiver. I've just never had the ability to argue that another side waived anything, although they usually accuse me of doing it. And this is a very strong waiver. This qualified immunity defense was not brought up until after remand, and all of a sudden we're now dealing with common law qualified immunity, which was abolished in 1963 by Stone versus Arizona Highway Commission. And the other side says, oh no, it didn't do that. Well, that's exactly what Stone did. It abolished immunity for the government, and the only immunity it could abolish as of 1963 was qualified common law immunity. There wasn't any statutory immunity that it could have abolished. And the Stone case actually in many ways is very close to our case. It involved a failure to give proper warnings to motorists. In that case, it was a highway going up a hill, and toward the crest of the hill there were signs indicating a turn to the left. Well, unbeknown to the motorist, the highway had been straightened and there was no turn to the left, but the motorist started to turn to the left and ran into oncoming traffic, and a catastrophic accident resulted. Well, here we have employees who failed to give a proper, powerful, strong warning in an emergency situation to motorists on the highway, failing to let the motorists know that there was a wrong-way driver, failing to give them any hint about what they were supposed to do. All it just said was, oncoming traffic ahead, keep right. Doesn't really tell you a whole lot of anything about anything.
Isn't keep right at least a directive to do something?
Well, it should. Yes, there should be not only something that says wrong-way driver, but some idea of what you're supposed to do. Pull to the side, stop, get off the freeway, some direction, something powerful to protect motorists. And if it had been given, that could have made all the difference in the world. Whether it would have made all the difference in the world is the causation issue for the jury.
And this happened in 2014, correct?
Yes,
sort of at the infancy of these signs, these sort of movable signs, if you will. They have electronic data on them, and they can change if there's an accident or a Amber Alert, something like that, right?
Not really at the infancy. They were already being used across the nation and in Arizona for a number of years.
And does the record show how long they'd been used in Arizona?
Although we do have the Houston warning from 2008 and the San Antonio warning from 2011. They were being used across the nation.
My focus is really on what was happening in Arizona, but what if instead of posting the post that the state did, they did nothing? They didn't post anything. Would you still have your same claims?
We would have a different claim. It would not be the same claim, no.
What would that claim be?
Failure to, well, actually, it'd be a failure to warn claim, but we wouldn't be talking about the kind of language that's going into the failure to the sign at that point. We say you didn't give any warning at all.
But that would be more of a policy argument, though, as opposed to vicarious liability. And that would have been one where you would need an expert to say this is what the state should have done. Is that fair?
More of a policy argument, and you're edging really back into the old distinction that was usually made, ministerial function versus the discretionary function. And in Stone and in our case, you're really dealing with ministerial functions. The need to provide proper highway signs in 1963, and here the need to provide a proper warning on the system you already have in effect.
But you're
in
saying
2014.
ministerial, I confess I'm not completely certain what the difference is between discretionary or ministerial, but there's some suggestion that ministerial is something where you're just following instructions, whereas here this seems to be, there isn't an instruction in place as to what to put on the sign, and isn't that a discretionary call by these employees who have to decide what message should be crafted to go on this sign?
Well, sure, it's a discretion, but it's also, it's down at the down at the lowest level. What do we put on the sign? We've got an emergency, we need to put something on the sign, we're going to put something on the sign, what is it going to be?
But
So-
you're saying there's a category of of who gets to apply this discretionary principle, that the qualified immunity only applies to a certain level of government employees if they're exercising discretion?
If you're talking about qualified immunity, you edge into the really policy-making kind of decision under the common law. For instance, if Arizona Department of Transportation has a committee, they get together and say, we need to provide warnings, we need to have something ready to go if there's a wrong-way driver, and they come up with what's in the driver's manual, alert, wrong-way driver ahead.
But what's your best case for suggesting that it doesn't apply to any state employee who's exercising discretion?
Well, they're right down at the bottom. All you have to do is decide, what do we put on the sign? And you can say, in a sense, that's discretionary, but in another sense is, we got to get a message out right away, what should it be? And Boulware says, you got to have an alert word in there. You got to have something like danger and some sort of instruction of what to do. Very basic, right down at the level. Same thing as the guy putting up the sign that indicates a left turn when there's no left turn at all. You've got to have it's just some common sense here. Down at the bottom, people have got to come up with a warning that really matters, catches attention, and protects the public, and they didn't do it. Now, the consequences for that, the causation, the damages, all these other things, those are issues for the jury.
But I'm trying to get at whether there's a difference. If we're talking about qualified immunity, there's liability for gross negligence or kind of recklessness. I mean, do you think this fits within, is this gross negligence? And is that something that was alleged initially?
It's gross negligence. I don't think the word gross was used anywhere, but I'm not sure you have to use the magic word. This is negligence, and it's so extreme, given the stakes here, life and death, you got to get it right. And they didn't even come close to getting it right. They provided oncoming traffic ahead, keep right, doesn't take anything.
I thought your expert suggested that the keep right was helpful.
Well, that is somewhat helpful, but he was more specific. He says you need to give more direction than that, and you need certainly to have the danger word. You need to have something of danger, and the way to communicate that is wrong-way driver, like in the San Antonio warning, wrong-way driver. You need to alert people what the problem is. That didn't happen. And I believe reasonable jurors could say that this is indeed gross negligence under the extreme facts of this situation. And
the state's brief suggests that you didn't really you weren't raising vicarious liability until a ways down the road, that initially it was the department just didn't have a policy in place. What they were doing was inadequate. And if that's the case, that would suggest that you're not really alleging gross negligence up front. If you're trying to pitch it as department policy, that it seems like a different lawsuit than vicarious liability.
Well, the department policy problem is not in front of us. This court got rid of that. That's gone. What we're dealing with now is the negligence of these.
Right, but I'm trying to understand if your theory of the case initially was gross negligence, if the state was on notice that that's what they were responding to, or if that's...
Yes, I believe. Now, of course, the reason we're talking about gross negligence is the possibility that common law qualified immunity applies. If it applies, then we talk about gross negligence. But I believe under these facts it's sufficient for a jury to say, yes, under these circumstances, what has happened here would qualify as gross negligence. In the Walls case, there's certain factors. You know or have reason to know of facts that lead a reasonable person to realize that the conduct not only creates an unreasonable risk of bodily harm, but also involves a high probability that substantial harm will result. Now, these folks in the message center should have realized they're dealing with a highly dangerous situation, a driver going at extraordinary high speed in the wrong direction, and they needed to do something right away, because if they don't, there is a high probability that substantial harm will result, a high probability of death or significant injury, and yet they came up with the wrong warning. Is that enough for a jury? Can the jury say, okay, we get it, well, the warning was not enough, and under these circumstances, there should have been a much stronger, more specific warning? That's gross negligence to us. You let the jury decide these kinds of issues. You don't take it away from them. And that's what's happened here. Now, that pulls me back really to one of the underlying simmering issues is Stone versus Arizona Highway Commission. Over the years, the Arizona courts have sort of whiffled occasionally about what Stone actually means. But if you get back to the basics here, Stone is very clear. They're getting rid of immunity, all forms of
But immunity is different. Just absolute immunity is different than qualified immunity, right? They're getting rid of absolute immunity, but they're not saying we're doing away with qualified immunity. And I'm certainly not reading the statute as doing away with qualified immunity.
No, they're not. In fact, that argument's in the briefing from the other side. Well, Stone only dealt with absolute immunity. Wrong. Absolute doesn't appear in there at all. There's actually a very interesting footnote to Stone, if I ever get to that. I was going to save that for my rebuttal. A very interesting footnote that talks about the absolutism of sovereign immunity and the virtual insanity of opposing sovereign immunity in the United States after we fought a war against an absolutist tyrant. And the first thing that we do is to start reinstating sovereign immunity. It is just nuts. One of the most curious aspects of American legal history is that we bought into sovereign immunity. But be that as it may.
Sovereign immunity, to me, suggests absolute immunity. You can't sue the government.
No, you can sue. No.
But not. You're saying Stone did away with.
Well, it did away with the only immunity that existed, which was common law immunity. And the only immunity that existed really was, well, some people would say absolute immunity, but it was the common law immunity where you get into the gross negligence kind of ideas.
Counsel, how do we deal with cases that post-date Stone and post-date the statute, like Chamberlain, that appear to acknowledge the ongoing existence in a case-by-case limited way of common law immunity of some description? I view it as common law qualified immunity.
Right.
But how are we asked, you said, hey, Stone got rid of, just displaced the field.
Right.
But then we have these other cases that come in not only after Stone, but after the statute, and the statute itself doesn't pretend to sort of cover the field. 05 says, well, this doesn't alter pre-existing or other law on immunity. So how are we to, as an intermediate state court of appeals, how are we to wrestle with that?
Well, you wrestle with it by looking at Arizona Supreme Court cases, which overwhelmingly say Stone abolished immunity. Over and over it says that. There has been some odd statements over the years that exist. And from this court, especially, you occasionally see that, but it's gone. Qualified common law immunity is gone.
Doesn't Chamberlain really sort of recognize, which was decided in 86, recognize the validity of common law immunity?
No, not in this context, not at all.
So it doesn't at all, period, as opposed to this context? Because those are different
Well, definitely not in this context. And I believe if you look at all of the Arizona Supreme Court cases, they stand for the proposition that Stone abolished common law qualified immunity. But recall what happened in Stone. The court was very careful to limit the liability to the employees and maybe their immediate supervisors.
And I'm with you on Stone, but what I'm trying to do is to follow the history after Stone, to bring that current, and that's what I struggle with.
The history it's not the road less traveled kind of history, and there is certainly there's several forks in the wood and meandering back and forth. But I believe that the thread that matters most and it is clearest is when the court comes back to the theme of Stone and says Stone abolished immunity. Sovereign immunity is abolished after Stone, and then it invites, which is a big tragedy to me. It invites the legislature to come in and create absolute immunity if it wants to, and qualified immunity.
Well, and Ryan did that, and they answered that call, right? The legislature, yeah, but not in a comprehensive way.
No, which is the only good thing about the legislature coming in. And whenever the legislature comes in, I quake in fear.
But doesn't that suggest that there are at least remnants of common law immunity in Arizona?
I don't think so, Your
Okay.
Honor. No. I think after Stone, that qualified common law immunity is gone. They were very powerful and very clear about it. They also noted a very interesting thing, which I hadn't really thought about until I reread Stone for the second or third time last night. They mentioned, well, it's been a part of the common law for a long, long time that municipalities have a duty to maintain their streets in a reasonably safe condition, and if they don't do that, they're liable. How can they be liable if they have immunity? They don't. The common law has held them liable for long before we became a state.
Isn't one way to read Stone, though, is a distinction between the state and municipalities?
And they make that distinction, but they did note that it is a very curious situation here where we've had a recognition of municipal liability for unsafe streets, and now we're moving up to the state and we're getting rid of any sort of immunity that involves the state. And I had an appeal about this a while ago. That municipal liability for unsafe streets goes back to 1926 with actual on-the-point cases in Arizona. But if you go back into the common law, you're talking about the 1700s, 1800s, and 1900s that it's there, and it's been there.
And what do we make of the Spooner decision from this court? What's your view on?
Spooner's a mistake. I mean, Ms. Spooner could not be more wrong. I'm sorry. And I know it's this court's opinion, but it's just dead wrong.
And if it's not dead wrong, is there a way to distinguish it?
I don't think. Well, the only way I could think of to distinguish it would be go back to Stone and deal with the specific kind of case that Stone dealt with, which is really the specific kind of case here, where low-level employees made a terrible mistake involving highway safety, and the public paid the consequences. The state then could be held liable for what they did under respondeat superior liability.
And what do we do with the statement in Chamberlain where the court says that although there may be some government offices that require absolute immunity, we believe the general rule of qualified immunity announced in Grimm should govern the case before us. And then it says that qualified immunity protects government officials from liability for acts within the scope of their public duties unless the official knew or should have known that he was acting in violation of established law. And then later on, we believe that in the vast majority of cases, qualified immunity will adequately protect state executive officials. Do we disregard that language?
What you do with that language is compare it to Stone and go forward from there to the other cases that have been more precise in what happened. Grimm's the pardon case, correct? Yeah. We're not dealing with any sort of high-level discretionary decision like a pardon, which is a very important high-level policy-making kind of decision. We're dealing with very low-level employees dealing with highway safety for
Right, that's the application, but you just made a bold statement earlier that there was no immunity at all.
There is no longer qualified common law immunity, not after Stone.
Notwithstanding Chamberlain's.
Notwithstanding anything else. Stone is the benchmark. In Redgrave, Stone is again identified as the benchmark here, where you're talking about there is no longer any immunity after Stone. That's it. It's gone. Of course, there was waiver, big-time waiver. I'd like to reserve my remaining time.
All right, thank you, counsel.
May it please the court, counsel, I'm Doug Northup. My partner Jennifer Clyde is with me. We represent the state of Arizona. Judge Anderson granted summary judgment on all grounds except absolute immunity. This court did not, as plaintiffs suggest, say that this case had to go to a jury or anything of the kind. In paragraph 39 of the opinion, they specifically said, we reverse and remand to consider Dr. Bullhauer's expert testimony about the warning and determine whether summary judgment remains appropriate. And it absolutely did. This is based entirely accepting the opinion of plaintiff's only liability expert, which is Dr. Bullhauer. Qualified immunity absolutely exists in this state, and I will give you a litany of cases in a moment that say it does. Plaintiffs they admitted below in specific factual admissions that this warning involved discretion and judgment, and I believe counsel just agreed with that again. And as Judge Anderson pointed out and Judge Russell pointed out again, it was never alleged, much less any evidence presented, that these dispatchers were grossly negligent. We've pointed out two other additional grounds to affirm. Causation is one of them on two different bases. Plaintiff's reply brief does not even address those, and they're conceded. But specifically, Dr. Bullhauer, taken at his best, said a different warning might have changed the outcome, possibly could have changed the outcome. And the case law is clear, you must have causation to the level of probability. We also pointed out the
But
standard
the
of care.
Superior Court did not rule on that basis, right?
The Superior Court, Judge Russell, did not, saying he didn't disagree with our position, but he applied the loss of chance rule, which has no applicability here, and as the cases that we cited, or make the Faulkner case make clear, it's the same standard. Probability governs causation going to a jury because otherwise it's speculative. The Stone case...
But are you suggesting, I think one of the arguments is that it's mere speculation that the decedent saw the signs, but there was some evidence in the record that if he got on the freeway from where he was working, that there were two signs that he might have seen. Is that not enough to overcome an allegation that it's simply speculation that he saw the signs?
I don't believe any of that's in the record because Dr. Bollhauer, who again is their only witness on liability at this point, testified he didn't know where the decedent got on and whether he ever went under a wrong-way sign. But that's completely independent. Even if he saw the sign, the expert said only that, I think a different sign might or possibly could have made a difference. And that's not enough. It has to be to the level of probability. Now, on the issue of qualified immunity, you're exactly right, Judge Catani. The Stone case talked about what was called governmental immunity. Can you sue the government at all? But there are many cases, Supreme Court cases after Stone, that recognize the applicability of qualified immunity. The Grimm case, which was employees of the...
So, counsel, let's assume that there is common law qualified immunity. What about the ADOT operators, or what evidence is there that they were high-level executive employees or police officers or anyone who would benefit from that qualified immunity?
Well, they don't have to be high level. There's not some particular level. And in fact, the court has never said there's a line you draw at where you are in the organization chart as to whether it applies.
Is it only a matter of discretion?
Is what you're doing. Absolutely. And if you look at, for example, police officers, there was a Grimm case, there were employees of the Pardon and Parole Board. In the Portanova case, which was from 1981, the Supreme Court applied common law qualified immunity to statements by a police officer that he made to a news outlet while he was doing an investigation. And there are numerous cases like that. For example, the Chamber...
The initial thread, like with the Board of Paroles, seemed to be we don't want this to influence their decisions on whether, for example, whether to release someone, that they shouldn't have to worry about that, and we just want them to do the best they can. That seems different than an operator who's deciding what to put on a sign when we know there's a separate statute that says they're not going to be personally liable for anything. It's just the state's liability is what's at issue. But is that same incentive in place for this level of employee?
Absolutely, because we have to look at what these employees were doing here. The expert said, and the Court of Appeals agreed he wouldn't be qualified anyway, but he said there's no standard of care requiring use of DMS signs at all. So in this circumstance, and in paragraphs 18 and 19 of our statements of fact, we pointed out these folks had to decide, should I engage the DMS sign? Where should I engage the sign? And what should it say? And they specifically said you have to, on the moment, think about what
they didn't have to decide where. I assume there's only limited electronic signs. They had to decide which ones.
They don't turn them all on because that creates its own host of problems. This driver went about 35 miles the wrong way while they were trying to stop him, and they have to make decisions which portions of the highway should we put it on? Where might this person be going? But what should that warning say? And as the plaintiffs admitted, that involved the use of judgment and discretion. And in fact, the argument in this case that was made for such a long time was the reason the state was responsible for not having a policy is because it required the dispatchers to use their judgment and discretion. But these are trained individuals, and they came up with a warning that said, oncoming traffic, keep right. That is absolutely, probably a higher level of discretion than a police officer who's speaking to the press about what charges they may bring.
But doesn't Chamberlain tell us that exactly that type of activity, deciding, posting warning signs, is the type of activity for which no immunity for which immunity serves no worthwhile purpose?
Chamberlain, in a one sentence that you're referring to, I think reciting to the restatement, did say something about, well, warnings, but it didn't say what about warnings. Is it putting up an already assignment, we know what it's going to say? It just doesn't address it, but I think we have to focus on the conduct here. Again, what were these folks doing in posting this warning, and what kind of circumstance was it? Very fluid, very dynamic situation where they used their training and judgment to say we need to post it, here's where we need to post it, and here's what it's going to say.
And I understand those are different types of signs, but isn't the same sort of discretion in play when an ADOT operator not behind the boards, not behind the cameras, has to decide which of the printed signs to post and where to post those to direct traffic?
Well, and that's the hard thing about Chamberlain, because most of the time the signs you're talking about would be governed by MUTCD or something where they're told what to put up and where. And that's why Chamberlain, I've read that passage many, many times. It's just entirely unhelpful because it wasn't at issue in that case and the court didn't analyze it. And I think had they really thought about a situation like we're talking about here, you focus on what were they doing. Yes, they were exercising.
That's the problem with giving examples, right?
That when it doesn't really apply. I mean, the language is there, but I think when you compare that to the many cases, Spooner, the Grimm case, Pinal County versus Cooper that we cited, many, many examples where the courts have said in these types of circumstances, county officials that are alleged to have gone on a witch hunt against an employee, common law qualified immunity applied.
Counsel,
Go ahead.
Let me ask on a different topic. This case has been to this court now twice. The deaths occurred in 2014. I don't see the issue of common law immunity being raised before remand from the prior appeal. Now, I want to hear more from you, but it strikes me that's an affirmative defense, should have been in the answer. I don't see it. I see references to the statutory immunities for sure in the answer, but help me understand your response to appellant's argument on waiver.
Your Honor, 12-8-2005 was absolutely raised in the
Yes.
answer. When counsel said it wasn't, that was wrong.
I've read that text. Now,
Yes.
it's not clear to me that raises common law immunity.
Well, I mean, the statute says this article should not be construed to alter, affect, or modify any rules of tort.
It has three parts, right?
Pardon?
05 has three parts. The first part you just quoted a portion of. The second and the third part are more substantive as opposed to kind of what ground does this cover and what ground
Right.
doesn't it cover.
But in a notice pleading state, and we absolutely raised it, but Your Honor, to the second point, which is really important, if there was a waiver here, the waiver was by the plaintiff, because the only case that was ever argued before summary judgment was granted in the first appeal, they said the DPS dispatchers were negligent. Well, DPS is out of the case. And the theory always was, and only was, the state should have had a pre-approved scripted warning. So we were left with the situation when the Court of Appeals says, no, that's out. Consider just this very limited opinion of the expert. What the court left us was the only conceivable argument was one the plaintiffs had never made. And that was the dispatchers were at fault, and we raised that immediately when that became the case.
Did you amend your answer to include that?
We did not amend our answer.
Because it strikes me what you're telling me is that you didn't include it in your original answer because you didn't think it was at issue. It came at issue, from what I just heard, I think, after the decision in the prior appeal, and then it was raised by motion, but the pleadings didn't change.
Exactly, but neither did the plaintiffs amend their answer or their disclosures to say, here's this new theory that's left.
Well, and let me ask you, did your disclosures following remand raise common law immunity?
No, because what we did was we were asked for a report that we provided to then it was Judge Bailey on what's left, and the plaintiffs were still arguing, no, we can make this overall policy argument, and we said, no, that's out, and the only thing that might be left is this, other grounds, causation, et cetera, but there were no amendments done by any of the parties to and we went right back to summary judgment and used the evidence that was in the record on summary judgment. But again, if we're going to say there was a waiver, The plaintiffs never raised that argument. In fact, even when we were arguing about the form of the judgment in this case, to that it was Judge Agnew, they were still making the argument that, no, we can make the argument that you should have had a pre-approved, pre-scripted warning. Their focus never had been on, and in fact, we quoted the questions that were asked by plaintiff's counsel, Mr. Leader, in the TOC operator's deposition, and he said to her, no one is suggesting that you did anything wrong, you were trying your very, very best, no one's criticizing you at all. So again, I've never had in 30 years a situation where because of that limited ruling on the Daubert motion, there was a theory left that had never been advanced before. But I think to say that we waived it, even though the plaintiffs never even specifically raised it, would be inappropriate. I think under the circumstances, we absolutely raised it as early as we could. And don't forget, Your Honor, in the summary judgment response, plaintiffs didn't even address qualified immunity, common law qualified immunity, at all. They never raised that until after summary judgment had been in a motion to reconsider. So if we want to talk about waiver, there are multiple levels of waiver here that would apply, but certainly we raised it, and I think the law is pretty clear, at the earliest opportunity that we had. And we made it clear in that motion what our argument was, and again, it was just ignored.
What's your best case for the thought that common law immunity was timely raised and preserved here?
Our best case that it was raised and preserved? Well, let me ask Ms. Clyde to pull a case. I mean, I think the law is pretty well established that it's notice pleading. Again, we're raising an issue, an argument that's never been raised before against us, right? It wasn't like this was raised and we just forgot about it and then came back to it later on. I mean, the Faraji case we cited versus City of Phoenix says the sheer passage of time doesn't support a waiver here. The courts look at it is, have you engaged in conduct that would be inconsistent with asserting that particular defense? And again, we looked at it when we came back from the Court of Appeals and said, what in the world is left here? And even though the plaintiff still continued making the argument, it was this policy issue that paragraph, I believe, 39 of the opinion made clear you couldn't bring it. We raised it as soon as we absolutely could, and our conduct was not inconsistent with that, and it was in the answer, Your Honor.
The common law immunity was in the answer? I'm sorry.
In the answer?
You said something was in the answer, and I wanted to make sure.
We cited the 12-820-05.
Okay.
The statute, yeah.
Got it.
And again, I think it'd be a pretty harsh result to say that the defendant can waive an issue that the plaintiff never raised. We dealt with it when it came up.
Can I ask, do you see some sort of limiting principle for when something is discretionary? It seems hard to, it seems like just about everything a state employee does, unless you're just following exactly some instructions that have been given to you. Any level of discretion, you're saying, results in qualified immunity?
Well, it's an interesting question because there have been courts that have said, well, like, I mean, when you're driving around in a car, that's not discretion even though you make decisions. I can't cite you to a case that says there's a clear, bright line, but I think when you look at what was involved here, and also the fact that Dr. Bollhauer, at his deposition and as a record stands in this case, never said there's any standard warning that has to be given or should be given. And in fact, when he was asked, he said, I don't even know what warning I'm really saying should have been given. Here's a couple from Texas. So the fact that even their expert didn't come up and say, there's a warning you need to give, shows it's discretionary. Do you say oncoming traffic or do you say wrong way driver? There's a whole dispute in the literature about whether you should give guidance, move right or not, because if you say move right and they get in the head on, now you've given them guidance. Again, that just shows that discretion goes into this.
So back to my colleague's question, what would our holding look like? What is the rule? When is that decision entitled to qualified immunity?
Well, I think to follow the cases that are out there that just state when you're exercising judgment or discretion, and in this case it's really easy, Your Honor, because in the index of record 158, the statement of facts that we cited in paragraph 18, we specifically said TOC operators would use discretion to select which DMS to use, observing factors, different factors they need to take into consideration. And paragraph 19, there isn't a pre-approved message, and therefore the DOT instead relied on the TOC operator's judgment to draft messages, and those were specifically admitted. So I don't think we need to make some broad rule to say where do we draw the line, but we have employees who were doing exactly what the cases say common law qualified immunity applies, and that was exercising judgment discretion about something that rises to the level of, do we use a sign, where do we put it up, and what is it going to say?
What's your response to the assertion that it is gross negligence, in particular the oncoming traffic, as opposed to wrong-way driver? Why isn't that something they should be entitled to argue to a jury?
Well, first of all, gross negligence was never alleged in any pleading disclosure statement at all, much less any facts. As Judge Anderson pointed out, and Judge Russell, he specifically said, Mendoza does not allege that any ADOT employee intended to cause death or act in a grossly negligent manner. But more important, the standard is, knows or has reason to know facts which would lead a reasonable person to realize his conduct not only creates an unreasonable risk of bodily harm, but involves a high probability it will occur. These dispatchers were trying to help. Counsel admitted that, his own words. No one is going to dispute that her heart was in the right place.
And any witnesses, though, besides what counsel was saying? So you're saying the expert was the only one who...
And he didn't say, I have this sign or this warning fell below the standard of care. He said, I like a different one better. And that goes into, frankly, the standard of care argument that had been rejected, but is another ground here. But again, there's just no evidence at all that these folks, putting up a sign, no one suggested putting up this sign made it more dangerous than no sign at all. It says oncoming traffic, keep right. That's a warning. And again, to show, and the courts have over and over granted summary judgment, and this court and the Supreme Court has affirmed that in these types of circumstances, ordinary negligence, maybe they have some kind of an argument, but it's a high standard. It's not, I forget which one of the cases said, it's not in the air, so to speak. But there's nothing here, especially where they admitted the very facts, and it's in the record where counsel specifically said, we know you were trying to help. We know you did your very best job. And the expert can't say, oh, this clearly was the wrong sign. That's the whole problem. And the only liability witness that exists in this case now is Dr. Bohauer. So I think overall I'm about out of time. The argument that qualified immunity doesn't exist is just wrong. Many of the cases, there are a couple more, I don't think it seems to be much in controversy, but we have cited many in the brief. There wasn't a waiver here, it was raised, it applies, the facts are admitted, there's no gross negligence, as two judges have recognized so far. And then there are the other grounds for affirming it. And again, I understand Judge Catani, your point about, well, could they figure out that he'd gone under a sign or whatever, but again, without some evidence that probably, and if we look at plaintiff's reply brief at page 25 and also page 11 where they cite their own expert's testimony, Dr. Bohauer could testify that a different DMS warning might have impacted the behavior of motorists on the freeway. And causation generally is a question of fact, but it's not when it would be speculative. So for all of these reasons, we would ask that you affirm the judgment below. I'm happy to answer any further questions if your honors have any.
Thank you, counsel.
Even in a gross negligence case, there can be discretion. That makes sense. I mean, just about everything that an employee does for the state involves some sort of discretion. Do I turn left? Do I turn right? Do I post a sign? Do I not post a sign? What do I put on the sign? All those are discretionary things. In Chamberlain, I'm glad you highlighted that part, Judge Cruz, where it says that certain types of activities, such as posting warning signs specifically, are the types of activities for which immunity serves no worthwhile purpose, and it really does not. But also in Chamberlain at page 554, the court indicated that if the immunity turns on disputed factual issues, then the jury decides the facts, and the court determines that the facts establish immunity.
What
The jury
immunity?
decides
Qualified
the facts.
immunity?
Pardon me?
Qualified immunity?
Any kind of immunity, Your Honor, including qualified immunity.
But don't you have to have some suggestion that there's gross negligence, assuming there's qualified immunity? Wouldn't you need your expert or someone to say this was gross negligence?
No, I'm not sure that experts are allowed to say that something is negligence or
at
gross
least
negligence.
opine that what they did was was incorrect.
Yes, below the standard of care, which he did opine, and in fact, if you go to the plaintiff's controverting statement of facts, which is index of record 45, paragraphs 72, 75, and 76, he talks about the standard of care, and he talks about causation in paragraphs 86 to 90. And that was in the record. Also in the record, back on remand in index of record 162, pages 10 to 12, the first time that we were back, and they filed a motion for summary judgment, we're responding to it, we say, no, there is no immunity. We didn't waive immunity. And then when they ratchet up the scales, they lose the original motion for summary judgment on the second time around. Then they filed this motion for reconsideration. We have common law qualified immunity. And they beat that drum like crazy. We respond to that, fight that off as best we can, and lose on qualified common law immunity, although Stone abolished it. And the cases that following that, Grimm, for instance, you talk about a high level, the board of paroles making a very important decision about what happens with the release of a violent person. That's not what we're dealing with here. We're dealing with the basic people down in the trenches. They've got a situation right in front of them. What do? When we talk about standard of care, I've run out of time. I will stop talking.
Thank you very much.
Thank you very much.
We thank you for your arguments. This matter is now taken under advisement, and we will issue a decision in due course. We're at recess.